My guest today on Salon Radio is Democratic Congressman Jerry Nadler of New York, whose bill, the State Secrets Protection Act, was just approved last week by the House Judiciary Committee by a vote of 18 to 12, and if it passes the House and Senate, it will be the first bill, the first law ever, to regulate the state secrets privilege. Congressman, thanks for joining me. Let me ask you to begin by explaining what the principal points of this legislation is and where does it go from here?
Well, let me just start with one bit of background. As you have pointed out in your many articles, there's an old maxim in law, and that is there's no right without a remedy. If you can't enforce a right, it doesn't matter what the Bill of Rights says or what the Constitution or anything. And if the government invades your rights, if it kidnaps you and sends you to Syria to be tortured, if it invades your house, ransacks your papers, steals your guns, for the conservatives among us, whatever, what's your remedy? Your only real remedy is to sue the government in tort for damages or to sue for an injunction to say stop. That's your remedy. But if the government can simply walk into court as soon as you file the complaint and file an answer saying dismiss the case because the consideration of the case would necessitate the revelation of state secrets that would endanger the national security, and the case is dismissed just on the magic incantation of the words state secrets, then you can't enforce any right, and none of us have any rights. The Bill of Rights becomes like the Soviet Constitution of 1936, which read very nicely, but didn't mean anything. So we've got to change that.
Okay, let me stop you right there, because you had a quote from last week that I found really striking that I was about to ask you about, and you sort of answered it, but I want to ask you about another part of it. You said, quote, "The state secrets doctrine, as it has been reinvented in the last few years, is the greatest threat to liberty in this country." Now, that's a fairly strong claim, and I think you just explained part of why that is. What do you mean when you say the state secrets doctrine as it has been reinvented in the last few years?
Well, it was clearly reinvented because for 50 years, from the Reynolds decision by the Supreme Court in 1953, it was an evidentiary privilege. That is to say, the government could not stop a trial, but it could go into court and say, that document that you want in evidence, that piece of paper, that whatever, you can't have that piece of evidence because that piece of evidence is a state secret. And so it would shield a piece of evidence, but it would not stop the trial right up front. The Bush administration made two changes, both of which have been embraced by the Obama administration. One, it started using this doctrine, which was used very sparingly before all the time, and secondly, it invented not only saying that you can't see a document, but it invented the use of saying you can't have a lawsuit, of coming into court right on the pleadings, right after the initial filing of the initial complaint, and saying stop the lawsuit because not that you can't see a document, but the very consideration of the lawsuit, the very consideration of the case will endanger state secrets. Dismiss the case right off the bat, and that hides everything. If you dismiss the case right off the bat, then you can't use the case to find out what's going on, to prove that the government is violating rights, is engaging in torture, is wiretapping without a warrant, or whatever. That's what I meant by reinventing. It was never used until the Bush administration, to dismiss a case right up front.
And you feel that it's fair to say, as I think you just did say, that in cases involving rendition brought by victims of torture, people alleging they were subjected to illegal warrantless eavesdropping, that the Obama administration has been using this privilege in exactly the same way, meaning in this way that's reinvented by saying not just these specific documents are subject to the state secrets privilege, but the subject matter itself is.
Yes, they've said that in court on a number of occasions. And they've on a number of cases, the El Haramain case, and other cases, the Jepson case, they've taken exactly the same position, saying that you can't consider the case, as the Bush administration did, and they've argued in courts and in appellate courts, and they sought review to defend that position. Now I've been talking with the administration since January about this, and what they've been telling us is, we're reviewing the policy, but meanwhile they go into court and take obnoxious positions.
Now, but except
finally,
yep. Go ahead. I was just going to ask you about the DOJ.
Finally, they came out with this new position, the Attorney General, a few weeks ago. But what that position amounts to is we will use the doctrine more sparingly, and that may be true, No one person in the administration will have the ability to make the decision. It will have to be a group of people, committee. We'll review each case very carefully. We'll be more sparing in its use, and we'll report to Congress. All that's fine, but all of that is minuscule because it still reserves to the executive branch the absolute power to try to stop any case, the absolute right. The court, the Ninth Circuit, the three-panel judge of the Ninth Circuit, in one of the cases says the executive cannot be its own judge. That is key to the American system of justice. That's why we have three branches, that nobody can be your own judge. If the executive commits an act which someone else alleges is improper or is a crime or whatever, you go to court. The court has to judge that. And they're still saying, with respect to this, trust us. We won't use this doctrine when we shouldn't. Trust us, but the court can't review it.
Right. And even subsequent, of course, to the announcement by Attorney General Holder, there was a case just 2 weeks ago alleging warrantless eavesdropping, illegal warrantless eavesdropping on the part of the Bush administration, and the Obama DOJ responded by asserting the state secrets privilege as a way to get rid of the entire lawsuit.
And it may very well be true that before they did that, they had more people review it within the department, had more people look at it and look at it carefully. But so what?
Right. Now, let me ask you about the specific legislation. What is it that your legislation would do principally that would curb these dangers and abuses?
Essentially, the legislation would do two things. It gets a little more complicated, but essentially would do two things. One, it would say you cannot use the state secrets doctrine to block a case right off the bat. You cannot challenge right on up front on the pleading and say you cannot consider the case because it would reveal state secrets. You can move to suppress an individual document or evidence or whatever, and it's conceivable that if all the evidence is suppressed, the case collapses, but that's because the evidence is suppressed. Secondly, if the government says this document or this evidence, whatever it is so sensitive that you can't use it, it's got to go, the court has to judge that, not the administration. The court must hold a suppression hearing, an in-camera secret hearing, in which the administration has to allege and prove to the satisfaction of the court why that evidence is so secret and so dangerous that in fact it cannot be used in open court. And it may be. I mean, there's some things that are. And if it proves that to the satisfaction of the court, and the court agrees with it, then it's got to see if it can make a summary of the evidence or a redacted version of the evidence that can be opened up and that can be used in court. And that's essentially the bill. I mean,
right.
There's some more details, but those are the essences.
Right. Now, let me just finish up with a couple questions about the procedure and the politics of how this bill can become law. There was some speculation, it was just speculation, but it was there when the DOJ announced its internal guidelines that part of the intent was to render legislation unnecessary on the grounds that the Justice Department is now solving the problem. Have you heard from the White House, either formally or informally, about what their position is on the need for this legislation?
They have so far said they're agnostic on the legislation. They have not taken a position. As I said, we've been talking to them. We've been trying to get them to agree to support the legislation. And I must say that it's not the White House, the Justice Department we've been talking to. And the counsel's office in the White House, too, but mostly the Justice Department. And I think it's fair to say they've been slow-walking it, and it's been taking months and months. We've been talking to them about it since February, since they came into office. And they've not taken a position. Now, hopefully, with the first-time approval by the entire Judiciary Committee of this bill, I know staff is meeting with Justice Department staff this week, today and tomorrow, in fact, my staff. We can get them to be a little more forthcoming. Also, there are some people who suggested that maybe we ought to put this into the same bill with the Patriot Act reauthorization.
Is that something you're considering doing?
It's something I want to do. I don't know whether I can.
Right. Do you have any indication at all from House leadership about their willingness to bring this bill to the floor now that the Judiciary has approved it?
Not yet. I think the safest thing to say, the fairest thing to say about House leadership is that they've been completely and totally preoccupied with health care.
Right, that's fair.
And to consider this yet. We've been talking to to leadership on the staff level, and we're dealing, and they're interested in this legislation. But I don't think we can say anything more than that. Obviously, they're going to have to make some decisions because, I mean, we reported, the Patriot Act reauthorization with the changes that you're familiar with at the committee also this week, and that's supposed to, that's got to be taken care of. The legislation, it will lapse if we don't approve it by the end of the year, and so they're going to have to pay some attention to it, one way or the other.
Absolutely. Well, I don't think that it can be overstated the importance of this bill that you're sponsoring and pushing for the reasons that you explained quite well. So hopefully there will be some mechanism for the people who care about it, and there are a lot of them, to start exerting some pressure and help.
Well, I hope so. They should exert pressure on the leadership of both houses. One of the basic problems is that I have to think that the administration is not going to support the bill, and it's going to be very difficult to pass it. When you have a Democratic president, and if they put out the word that they don't want this bill, it's going to be very difficult to pass it in the House.
Right. There's supposed to be that whole separation of powers thing and members of Congress acting independently, but I guess that's theoretical.
And that's true to some extent, but of course the administration and politics plays a large role, as we all know.
Absolutely. Well, I really appreciate your efforts. I think it's, as I said, an incredibly important bill that you're working on, and I appreciate your taking the time to talk to me, and we'll definitely be following. Well,
thank you. I think I got to say, I spent a considerable amount of time working with John Conyers and Bobby Scott also on the Patriot Act. I think this is, frankly, more important than the Patriot Act.
Yeah, absolutely. I agree completely, and I've been writing about it a lot, as you know, and we'll continue to follow it.
Good.
Thanks, Congressman. Appreciate it.
Thank you.
Bye-bye.